Welcome to Law Visit. In this video, we will understand the difference between seat and venue in arbitration, and secondly, who determines the seat of the arbitration. Although the terms seat and venue have not been defined in the Arbitration and Conciliation Act of 1996, yet it is very crucial to understand the difference between the two as it has very practical application in the arbitral proceedings. Section 2 and Section 20 of the Act of 1996 uses the term place. Section 20 has further three clauses 1, 2 and 3. The clause 1 and 2 of section 20 corresponds to seat of arbitration, whereas clause 3 of the section 20 corresponds to venue of arbitration. Now let us understand the difference between the two. The seat of arbitration basically is the jurisdiction of the arbitration, whereas the venue of arbitration is the location where the arbitral proceedings are conducted. Now let us understand it through an example. For instance, in an arbitration, if the seat of arbitration is fixed as Delhi, and on the other hand venue of the arbitration is fixed as Chandigarh, then in that case, if the arbitral award is challenged, the jurisdiction will vest with Delhi High Court because the seat of the arbitration was with Delhi. On the other hand, the proceedings will be conducted at Chandigarh because the venue was fixed as Chandigarh. This difference has been clarified by the Honorable Supreme Court in a landmark judgment, Bharat Aluminium Company versus Kesar Aluminium Technical Services 2012. Now let us come to the second question, that who will determine the seat of arbitration. As we know, the law of arbitration is based on party autonomy. Therefore, parties mutually decide the seat of the arbitration at the time of entering into arbitral agreement. However, if the parties do not define or forget to define the seat of the arbitration in the arbitral agreement, then one of the party under section 20 clause 2 can make an application to the honorable arbitrator or the arbitral tribunal to decide the seat of the arbitration. There is yet another major difference between seat and venue of arbitration. Seat of the arbitration, once is decided by the parties or by the arbitral tribunal, cannot change unless it is again mutually agreed between the parties to change the seat of arbitration. However, venue, being merely a location where the arbitral proceedings are conducted, is not stationary and can change. I hope after watching this video you are clear what is the difference between the seat and venue and place of arbitration and how is the seat of arbitration determined. For more such content, keep watching Law Visit.